On the 1st of January 1886, a post-mortem examination found a fatal quantity of liquid chloroform in the stomach of Thomas Edwin Bartlett. Liquid chloroform destroys soft tissue on contact, the lips, the tongue, the lining of the throat, the esophagus. A lethal dose cannot pass from the mouth to the stomach without leaving its evidence on every surface it touches. Edwin Bartlett's throat was clean, his esophagus was undamaged, no burns, no tissue damage, no chemical trace anywhere above the stomach. The chloroform was present. The evidence of how it arrived was not. 3 months later, his wife Adelaide stood in the dock at the Old Bailey charged with his willful murder. The law of England did not permit her to speak in her own defence. Her barrister spoke for 6 hours in her place. The question at the centre of this case is not simply how. The question is, what does it mean that the only system available to answer that question was one that had already decided what kind of woman she was? Pimlico, in 1886, was the kind of neighbourhood where respectability was not merely expected, it was performed. Its residents were the prosperous middle class, grocers, merchants, minor professionals, men who had made something of themselves and who lived in a manner that demonstrated it. Terraced houses, maids, good addresses, the careful architecture of social arrival. This performance was not decorative. In Victorian England, middle-class respectability had a specific function. It was the mechanism by which a family's position was maintained and advanced. To fall below it was to invite consequences that were financial and social simultaneously. The terraced houses of Pimlico were not simply homes, they were daily demonstrations that their occupants had earned the right to remain. Within this world, women occupied a particular legal position that modern audiences rarely understand with full clarity, and which is essential to understand before a single other fact, in this case, can be properly read. Under the doctrine of Coverture, which had governed English law for centuries and which, in 1886, was still substantially intact, a married woman had no independent legal existence. At the moment of marriage, her legal identity was absorbed into her husband's. She could not own property in her own name. She could not enter contracts independently. She could not sue or be sued as an individual. She could not control money she had brought into the marriage. She could not open a bank account without her husband's authorization. She couldn't leave a marriage without his cooperation. Without financial resources, she was legally barred from accumulating independently, and without the kind of social catastrophe that Victorian respectability made ruinous. The Married Women's Property Act of 1882 had begun to address this. Women could, in principle, retain property they had owned before marriage or inherited independently after it. But the practical reality of Victorian middle-class life was only slowly responding to legal revision. The culture of coverture outlasted the statute by a generation. What did this mean in practice? It meant that a woman in Adelaide Bartlett's position had precisely one mechanism for managing her circumstances: the goodwill of her husband. If he was reasonable, she lived reasonably. If he was eccentric, she inhabited his eccentricities. If he chose, for reasons of his own, to design her life according to specifications she had not requested, she inhabited those specifications. The law provided no exit, No independent financial resource, no voice in the institutions that governed her existence. She was, in the language of Victorian law, his. The language was not metaphorical. This courtroom, the one that would eventually contain Adelaide Bartlett, was composed entirely of men who had never been required to inhabit her legal position, who could not be required to, because the law that structured their world also structured who was permitted to sit in judgment within it. There is a phrase that gets used in histories of this case. It appears in legal commentaries, in newspaper accounts, in the subsequent academic analysis. The phrase is, "the evidence against her." Before we examine that evidence, you need to understand the world that produced it, because the verdict in this case was not assembled in a courtroom. It was assembled in the world I have just described, by the logic of that world, by men whose understanding of what a woman in Adelaide's position should look like was shaped entirely by a law that had never asked her. Before we look at what Adelaide Bartlett did or didn't do, you need to understand what England had already made her, because what the system called evidence and what the system called guilt were not separate questions. They never had been. Adelaide Blanche de la Trémoille was born in Orléans, France in 1855. The identity of her father was never publicly established. He was understood to be a man of considerable social position, a French gentleman for whom Adelaide's illegitimacy represented a problem of management rather than a daughter of relationship. What the record confirms is that he took an interest in her welfare, and that when Adelaide was 19 years old, he arranged her marriage to Thomas Edwin Bartlett. She was not consulted in any meaningful sense. She was 19. He was 30. The arrangement was financial as much as matrimonial. A substantial dowry accompanied Adelaide. In exchange, Edwin accepted full responsibility for her education, or her behaviour, her social formation. By the standards of Victorian England, this was not unusual. A woman was transferred from the custody of one man to another, with financial instruments attached to confirm the transaction. What was unusual was what Edwin chose to do with the arrangement once it was complete. Within weeks of their marriage in 1875, Edwin sent Adelaide away, not in anger, by deliberate design. He enrolled her in a boarding school to complete, he explained, the gaps her French education had left. She spent the next 2 years divided between that institution and a finishing school in Belgium, returning to her husband only during school holidays. Their life together, in any conventional domestic sense, did not begin until 1877. What Edwin Bartlett intended by this arrangement has been disputed since the trial. The charitable interpretation is of a man who believed education was the proper foundation for a marriage of minds. The less charitable interpretation is of a man who preferred his wife at a careful distance while he designed the version of her he wanted delivered. Both may be true simultaneously. What is documented is that by the time Adelaide returned to her husband's house as a permanent presence, Edwin Bartlett had developed a philosophy of marriage that he made no particular effort to conceal. He stated on more than one recorded occasion that a man ought to have 2 wives, one for companionship, one for domestic purposes. He said this to his father. He said it to acquaintances. He said it eventually to George Dyson. Adelaide was, in his schema, the companion wife. Their physical relationship, based on her consistent account and corroborated by the absence of any further pregnancies after the first, had effectively ended. That first pregnancy carried the particular cruelty that seemed to follow Adelaide Bartlett through her life. When Adelaide's labour became difficult, her midwife recommended that a male physician be called. Edwin refused. No man, he stated, would interfere with his wife. The birth was managed without medical intervention. The child was stillborn. After that, by all accounts that could subsequently be gathered, the physical dimension of their marriage ended. Adelaide did not become pregnant again. Their life together became what she had always claimed it was designed to be, a careful, yet arranged coexistence between two people inhabiting the same residence under terms one of them had set and the other had not been asked about. By the autumn of 1885, Adelaide Bartlett was 30 years old, childless, legally bound to a man she had not chosen, living in a terraced flat in Pimlico, inhabiting a marriage constructed entirely according to her husband's specifications, with no independent income, no property of her own, no legal mechanism by which to renegotiate any of it. Here is the detail that every account of this case presents as the beginning of Adelaide's transgression. In the spring of 1885, Edwin Bartlett introduced his wife to the Reverend George Dyson. Dyson was 27, serving a Wesleyan congregation in Putney, educated and personable. Edwin hired him to continue Adelaide's studies in Latin, history, and geography. George came to the house. He tutored. He visited with increasing frequency. And over the following months, Edwin actively encouraged a closeness between them that went considerably beyond tutorial instruction. Witnesses testified at trial that George Dyson and Adelaide kissed on the lips in Edwin's presence, that Edwin expressed satisfaction at what he saw, that a maid had found them in a darkened sitting room in a position of intimacy, and that no one in the household had treated this as requiring explanation. Edwin paid for Dyson's railway season ticket from Putney. Edwin wrote to him warmly. Edwin, in September of 1885, revised his will to remove the condition that Adelaide not remarry after his death. Edwin Bartlett constructed the arrangement around all three of them, then arranged for it to continue after he was gone. Every account of this case presents Adelaide's relationship with George Dyson as the evidence of motive. What every account handles more carefully is the question of the man who built the situation and what his design reveals about what Adelaide's life actually consisted of. By the autumn of 1885, Edwin Bartlett's health had deteriorated significantly. The dental neglect of years had reached a crisis. Stumps of rotting teeth remained in his jaw, generating an infection that his physician, Dr. Alfred Leach, who had taken Edwin on as a patient that September, found alarming. The smell was, witnesses would subsequently confirm, considerable. Adelaide had long since moved her sleeping arrangements to a cot at the far end of their shared bedroom. Dr. Leach treated Edwin across the autumn. Dental work was eventually undertaken, a painful, protracted process. Edwin's general health remained poor, his sleep disrupted, his mood variable. His energy, which had previously sustained a modest but functioning business, was now unreliable. It was in this context, the rotting teeth, the failing health, the disrupted nights, the coexistence in a bedroom they no longer shared as a married couple in any conventional sense, that Adelaide Bartlett, on the 27th of December 1885, asked George Dyson to obtain chloroform for her. Her stated reason, given consistently across the statements she made before trial, was this: Edwin had recently indicated, for the first time in years, that he had tended to resume the physical dimension of their marriage. He had said this to her directly. Adelaide wished to use chloroform to prevent it. A small quantity, held to his nose on a handkerchief if he approached her during the night, would render him temporarily insensible without harm to either of them. Medical use of chloroform as a short-term sedative was not, in 1885, implausible in principle. Whether Adelaide's specific application was medically coherent is a separate question. George Dyson procured the chloroform, not from one chemist, from 4. He purchased small quantities from 4 separate pharmacies across 2 days, offering a different explanation at each, a variation on a grease stain removal story. He combined the bottles into a single larger container and delivered it to Adelaide on the 29th of December. He did not ask her, in any meaningful detail, what she needed it for. There was one aspect of this transaction that the prosecution raised at trial but never adequately explained. Why 4 chemists? If the purpose was stain removal, a single purchase would have sufficed. If the purpose was what Adelaide claimed, a small supply for occasional deterrent use, the quantities assembled across 4 separate shops represented considerably more chloroform than her stated application required. Keep that question. We'll come back to it, because the answer looks different once you have the complete picture. Edwin Bartlett had rallied in recent weeks. Dr. Leach's records indicate his health had stabilized. He had eaten a substantial supper that evening, haddock, documented at trial, and retired with Adelaide to their bedroom. Adelaide, in her subsequent statement, said that Edwin had that evening spoken of resuming their physical relationship fully, that this was the context in which she had placed the chloroform bottle on the mantelpiece, within reach for its stated purpose, if needed, in the night. She sat at his bedside. At approximately 4 o'clock in the morning of January the 1st, 1886, Adelaide went to the door of their room and summoned the landlord's wife, Mrs. Doggett. She said she thought Edwin was unwell. He was not unwell, he was dead. Dr. Leach was summoned. A post-mortem was subsequently conducted. The findings were precise. A fatal quantity of liquid chloroform was present in Edwin Bartlett's stomach. Liquid chloroform is caustic on contact with soft tissue. The passage of a lethal quantity from mouth to stomach destroys every surface it touches: the lips, the tongue, the throat, the esophageal lining. The resulting damage is unmistakable and extensive. Edwin Bartlett's mouth was clean, his tongue was clean, his throat was clean. His esophagus showed no damage of any kind. His expression, those who found him noted, was peaceful. The post-mortem also established that Edwin had died some hours before he was found, in a position on his back that showed none of the convulsive symptoms that a conscious person experiencing the burning of liquid chloroform on soft tissue would physically be unable to suppress. The chloroform was present. The mechanism by which it arrived was not. I want you to hold what you have just heard, because the next section is not going to tell you what happened on New Year's Eve. It is going to ask you to look at everything you have heard. The world Adelaide Bartlett inhabited, the marriage Edwin built, the chloroform she requested, the night she sat at his bedside. Through a specific framework. The framework is the one the system refused to apply. There is a category of person that a legal system finds particularly difficult to process. Not the violent offender, not the habitual criminal. The system has language for those and procedures and precedents going back centuries. The category that disrupts systems is different. The person who does not behave as the system expects, who exercises agency within a structure not built to accommodate their agency, and who therefore registers to that structure as inherently suspicious. Adelaide Bartlett was this person. The psychological framework required to understand what happened at the Old Bailey is not about Adelaide's mental state. It is about the mental state of the institutions that evaluated her. Victorian law operated on a set of implicit assumptions about women. These assumptions were not arbitrary, and they were derived directly from Coverture, the same doctrine that had structured Adelaide's marriage. The assumption was this: a woman of Adelaide's class and position was, by nature and by law, a person of circumscribed agency. She operated within domesticity. She deferred to male guidance. She did not act independently, particularly not in matters touching on her marriage or her husband's well-being. When Adelaide Bartlett departed from this model, when she obtained chloroform on her own initiative, when she managed a triangular domestic arrangement with evident composure, when she sat at her husband's deathbed through an entire night, and then summoned help without visible distress, she performed a version of female behavior the system had no mechanism to read as innocent. Innocent women, in the legal and cultural imagination of Victorian England, were passive. They were visibly distressed. They were dependent. They performed their helplessness in ways the system recognized. Adelaide Bartlett performed none of these things. I am calling this the category violation. The category violation is the mechanism by which a system designed to evaluate evidence instead evaluates identity. Adelaide was not processed by the inquest and prosecution as a woman who might or might not have administered chloroform. She was processed as a type of woman who, given what she had demonstrably done and felt and chosen, probably had. Look at what the prosecution treated as evidence of guilt. She had sought chloroform, which required identifying a need and taking independent steps to meet it. The prosecution called this premeditation. She had maintained composure throughout her husband's illness and death. Composure in a woman registered as control. Control in this context registered as calculation. She had a relationship with George Dyson, one her husband had encouraged, arranged, and funded. The prosecution presented this as motive: the adulterous wife, the lover waiting, the obstacle to be removed. Not one of these three things was inherently incriminating. Each of them was Adelaide exercising a form of agency within the constraints of a life she had not designed, but each of them, read through the framework of what a proper Victorian wife should look like and feel and do, registered as aberrant. and aberrance in a criminal investigation is read as evidence. Now return to the question I asked you to hold. Why 4 chemists? The prosecution's answer was premeditation. The deliberate, careful accumulation of a murder weapon distributed across separate sources to avoid detection. Here is what the complete picture of this case actually suggests. George Dyson was a 27-year-old clergyman purchasing a controlled substance for a purpose he did not fully understand. For a woman, he was not in a position to question, at a quantity she had specified. He went to 4 chemists because he was nervous about the transaction and did not want to be remembered at any one of them. He gave different stories at each shop, because he had no single explanation that was both accurate and sufficient. The grease stain story was not a cover for murder. It was the improvised response of a man doing something mildly uncomfortable and hoping to leave no impression. This is not an exoneration of Adelaide. What it resolves is the prosecution's most compelling circumstantial argument. The 4 chemists, presented as evidence of systematic, premeditated accumulation, is equally consistent with nervous improvisation as with calculated planning. The jury had no basis to choose one interpretation over the other. Clark's defense made this point. The medical paradox made it irrelevant in the end, but the question that the framework of category violation makes visible is more important than the 4 chemists. What did justice actually require in this case? The one thing the law of England refused to provide: Adelaide Bartlett's testimony. Not a barrister constructing her defense from the outside, not statements taken before trial and read into evidence by someone else's voice. Her account in the dock, in her own words. The chloroform, Edwin's philosophy, New Year's Eve, the night at the bedside. The experience of inhabiting the marriage he had built, the experience of being transferred at 19 from one man's custody to another's and spending the next decade inside a life designed entirely by someone else. The Criminal Evidence Act, which would eventually permit defendants to testify in their own defense, was not passed until 1898. Adelaide's trial preceded it by 12 years. The system that tried Adelaide Bartlett was built to determine guilt or innocence. It was not built to hear the person at its centre, and the person at its centre was, by law, the one person whose account was excluded from the proceeding. The category violation was not only about what the prosecution assumed. It was about what the law structurally ensured she could not correct. The trial of Adelaide Bartlett opened on the 9th of April 1886, before Mr. Justice Wills. The prosecution was led by Sir Charles Russell, the Attorney General. His case was built on the 3 pillars I have described: motive, the chloroform accumulation, and the composure of the woman in the dock. It was circumstantial from the first line. No witness had observed the chloroform administered. No expert could explain the mechanism by which it arrived in Edwin's stomach without damaging the tissue above it. The prosecution's argument was, at its core, a request that the jury reason from effect to cause and trust their instincts about the kind of woman who could have produced this effect. George Dyson was called as a prosecution witness. He confirmed the purchase, the 4 chemists, the separate stories, the combined bottle, the delivery to Adelaide. He positioned himself as a man who had been misled, who had acted in good faith without understanding the purpose, and had been used. He was not charged. Sir Edward Clarke, appearing for the defence, cross-examined Dyson with method rather than theatre. What he established, carefully and without histrionics, was a portrait of a man who had not been deceived into the arrangement, who had inhabited it comfortably for months, had kissed Adelaide in her husband's presence, had accepted the railway pass, had visited the flat under conditions Edwin had created and maintained, who had, when Edwin died and the arrangement became legally dangerous, chosen to reframe his participation as innocence. The jury heard a man narrating his own choices as victimhood. Clarke's closing speech lasted 6 hours. It has been assessed in Victorian legal history as one of the finest pieces of forensic advocacy produced at the Old Bailey in that era. What Clarke understood was that the prosecution had not explained the chloroform paradox. It had presented a conclusion, willful murder, and left the mechanism to inference. He returned, again and again, to the medical evidence, to the absence of tissue damage above the stomach, to the impossibility, as established by the prosecution's own expert witnesses, of explaining how a lethal quantity of liquid chloroform could have arrived in Edwin Bartlett's stomach without leaving any record of its passage. If Adelaide Bartlett had administered it without her husband's knowledge, the Clarke asked, by what method? If she had administered it with his knowledge in sufficient quantity to kill, what mechanism had prevented a conscious man from experiencing and reacting to the burning of caustic liquid on the lining of his throat? Neither scenario was clinically coherent. The prosecution could not answer the question. It could only ask the jury to assume the answer existed. The jury retired for 112 minutes. Although we think grave suspicion is attached to the prisoner, we do not think there is sufficient evidence to show how or by whom the chloroform was administered. Not guilty. The courtroom erupted. Contemporary accounts describe the applause as immediate and prolonged. The public gallery, populated largely by women who had followed the proceedings closely, were responding as though a long-held tension had finally broken. Adelaide Bartlett was free. She had never spoken. After her acquittal, Adelaide Bartlett withdrew from the public record. She gave no interviews. She made no statement. She sought no public vindication and offered no account of what had happened in the bedroom of a Pimlico flat on New Year's Eve, 1885. She simply stopped being visible. Edwin's estate, his property, his insurance at £400, his accumulated assets, passed to Adelaide. The condition that she not remarry had been removed from his will before his death. Whether she and George Dyson ever met again is not confirmed. Whether she married him, as Edwin had apparently designed for her future, is not confirmed. Whether she was innocent of anything, by any moral standard that accounts for the conditions of her life rather than only the contents of her husband's stomach, is also not confirmed. What is confirmed is Sir James Paget's response to the verdict. Sir James Paget, surgeon to Queen Victoria, Fellow of the Royal Society, one of the foremost medical authorities of his generation. His assessment of Adelaide Bartlett's acquittal, now that she has been acquitted for murder and cannot be tried again, she should tell us, in the interest of science, how she did it. He was not speaking as a prosecutor. He was speaking as a scientist confronted with an unsolved problem. And in the same sentence he assumed, the moment legal consequence was removed, that the problem was hers to confess. That assumption is the system still operating. The courtroom had emptied, and the verdict had been rendered. The law could no longer punish her, and the foremost medical authority of his generation immediately reframed her acquittal as an opportunity for her confession. Adelaide Bartlett is believed to have died in the early years of the 20th century. The exact date is not confirmed. The location is not confirmed. The name under which she may have lived her remaining years is not confirmed. She left no memoir, no published account, no testimony of any kind beyond the statements she gave before trial. The woman who could not speak inside the system that judged her chose, once that system released her, not to speak to the system that had watched. This may be the most coherent decision she ever made. Now I want to ask you something. And the question I want to leave you with is not whether Adelaide Bartlett poisoned her husband. The question is, by what standard could she possibly have been found innocent in a system that had constructed the conditions of her life, silenced her in the proceeding that judged it, and then assumed her guilt the moment conviction became impossible? 12 men said they thought she was suspicious. One surgeon said he knew she was guilty. Adelaide said nothing. Tell me where you stand, and tell me what you think Sir James Paget's certainty was really about, because I do not believe it was entirely about science. The chloroform is still in the stomach, the tissue is still undamaged above it. The method remains 140 years later, unexplained. Victorian England did not only convict women for what they did, it suspected them for what they were. Adelaide Bartlett's case made that visible. Her acquittal did not make it untrue. She kept her silence for the rest of her life. We can, at least, read the record she left behind. Crime Unsealed investigates the cases history tried to bury, using court records, inquest testimony, and primary documents. No speculation, no dramatization. The record read carefully. If that is the kind of history you are looking for, subscribe. Every case we cover is one the standard accounts have softened or set aside. The next one is already being built. The record deserves to be read.